Hello everyone, myself Somesh Saxena. Today we are going to focus on the topic ADR laws in India. Alternative Dispute Redressal. Alternative Dispute Redressal provides an alternative to going to court to settle disagreements. Methods include arbitration, where disagreed parties agree to be bound by the decision of an independent third party, and mediation, where a third party attempts to arrange a settlement between the two sides. ADR law in India. In India, laws relating to resolution of disputes have been amended from time to time to facilitate speedy dispute resolution. Traditional Benjamin Franklin once said, "When will mankind be convinced and settle their difficulties by arbitration?" I think in India can answer him by providing the example of panchayat system, which in reality is not very different from modern ADR system. In fact, panchayat system is worked in India from centuries. It is a process by which a neutral third party, usually a person of higher status and reputation, deemed to be unbiased during adjudication, will be rendering legally binding decisions. Unfortunately, this system has lost its credibility due to intervention of politics and communal hearted among people. Background of ADR. The Convention on Recognition and Enforcement of Foreign Arbitral Awards denoted New York in 10 June 1958. The New York Convention is described as the most successful treaty in private international law. It is adhered to be by more than 140 nations. The more than 1400 court decisions reported in yearbook commercial arbitration shows that enforcement of an arbitral award is granted in almost 90% of the cases. The convention was established as a result of de-escalation with the Geneva Protocol on Arbitration clauses of 1923 and the Geneva Convention on the Execution of Foreign Arbitral Awards of 1927. The initiative to replace the Geneva Treaty came from the International Chamber of Commerce, which issued a primary draft convention in 1953. Arbitration is the process of bringing a business dispute before a disinterested third party of resolution. The third party, an arbitrator, hears the evidence broadly by both the sides and makes a decision. Sometimes that decision is binding on the parties to arbitrate a matter is to bring it before an arbitrator. Arbitration is a form of alternate dispute resolution ADR used in place of litigation in the hope of settling a dispute without the cost and the time of going to the court. Mediation. Mediation is a method where neutral and impartial third party, the mediator, facilitates dialogues in constructed multi-stages process to help parties reach a conclusive and mutual satisfactory agreement. A mediator assists the parties in identifying and articulating their own interests, priorities, needs, and wishes to each other. Mediation is a peaceful dispute resolution tool that is complementary to the existing court system and the practice of arbitration. Conciliation. Conciliation is another dispute resolution process that involves building a positive relationship between the parties of dispute. However, it is fundamentally different than mediation and arbitration in several respects. Conciliation is a method employed in civil law countries like Italy and is a more common concept than is mediation. Negotiation, a non-binding procedure in which discussion between the parties are initiated without the intervention of any third party with the object of arriving at a negotiated settlement to the dispute. It is most common method of alternative dispute resolution. Negotiation occurs in business, non-profit organization, government branches, legal proceedings among nations, and in personal situations such as marriage, divorce, parenting, and everyday life. Lok Adalats. The organization of Lok Adalat, every state authority or district authority or the Supreme Court Legal Service Committee or every High Court Legal Service Committee or as the case may be Taluk Legal Service Committee may organize Lok Adalat at such interval and places and for exercising such jurisdiction and for the such area as it is thinks fit. Advantages of ADR. The resolution of disputes take place usually in private, helping maintain confidentiality. It is more visible, economic, and efficient. Procedural flexibility saves valuable time and money, and absence of stress of a conventional trial. This often results in creative solutions, sustainable outcomes, greater satisfaction, and improved relationships. Conclusion. Alternative dispute redressal is rapidly developing at national and international level, offering simpler method of resolving disputes. Increasing trends of ADR services can easily be inferred from the growth of arbitration clause in majority of contracts.